For today's story, we give Nick Rekieta a run for his money as we consider an alternative preacher to the Daily Unbreaded in the form of a Coast Guard lieutenant. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. Yes, as we all know, our good friend Nick Rekieta from Rekieta Law loves the Daily Unbreaded. He loves reading this manifesto from this one guy about, his feelings, this former postdoc student in California. Well, I have a story that may give its run for its money. Maybe it will lead to our own version of a Daily Unbreaded. But we have to get through it. This is United States of America versus Christopher Paul Hasson. In this case, Lieutenant Hasson is a lieutenant in the Coast Guard, and he's discovered with things. And these things lead to other things which concern the government. The United States government liked him when he was a lieutenant, not so much when they find him to be basically a terrorist in waiting. So we're going to read this, and let's get started with this. In February 2019, federal authorities arrested Hasson as he arrived to work at the United States Coast Guard headquarters in Washington, D.C. At the time, Hasson was a lieutenant in the Coast Guard. The sworn criminal complaint charges Hasson with unlawfully possessing tramadol, an opiate pain reliever, and a Schedule IV controlled substance, and possessing firearms and ammunition as an unlawful user or addict of a controlled substance. Okay, so yeah, they find that he's on this drug, which is a restricted drug. It's a controlled drug, and they think he's a habitual user. And under the relevant law, pretty sure it's 18 U.S.C. 928G, I believe, in subsection somewhere in there, that says that, among other things, you can't own firearms or possess firearms if you're a habitual user, unlawful habitual user of any controlled substance. So by being an unlawful user of a controlled substance, he's also in violation of gun possession laws. Okay, so how do we know that, he's a habitual user? What evidence do we have to suggest he might be a habitual user? Well, let's discuss some evidence. The arresting agents found 196 tramadol pills in Hasson's backpack and another 106 in his work desk. It's a lot of pills. It also uncovered other things that are concerning. 15 firearms, an unregistered assembled firearm silencer, an unregistered disassembled firearm silencer, and hundreds of rounds of ammunition. A blood sample was drawn from Hasson that day that showed the drug tramadol to be in his bloodstream. He might be a habitual user of the drug. In a motion to detain Hasson pending trial, the government claimed the charges were the proverbial tip of the iceberg. According to the government in its investigation, it revealed that Hasson, the lieutenant, was a domestic terrorist bent on committing acts dangerous to human life. Well, what evidence do we have of that? Let's read some more. The government claimed that the draft email dated June the 2nd, 2017, which it calls a manifesto, provided in a sense insight into Hasson's worldview. Now, at this point, I will break to note for the record, for the YouTube, I am not endorsing any of this. I am not agreeing with any of this, nor am I promoting it in any way. I am reading an official court document. I am describing what he had so we can understand the basis of the charges that are available. This is not encouraging. I'm not agreeing with this. Moving back to the story. In this manifesto, Hasson wrote that he was dreaming of a way to kill almost every last person on Earth and contemplated biological attacks followed by an attack on the food supply and instituting a bombing sniper campaign. Hasson continued in his manifesto, I don't think I can cause complete destruction on my own. However, if I could enlist the unwitting help of another power, country would be best. Who and how to provide? Liberalist, globalist agenda is destroying traditional people, especially white. No way to counteract without violence. It should push for more crackdown, bringing more people to our side. Much blood will have to be spilled to get Whitey off the couch. For some, no amount of blood will be enough. They will die as traitors who actively work towards our demise, looking to Russia with hopeful eyes, or any land that despises West liberation. Need to come off the TDL, clear my head. That probably is a good idea. Read and get educated. Have to move to friendly area to start to organize. Get leadership within community. Sheriff, city manager, mayor, lawyer? Not sure how to start, but need to start now. Be ready. Have to take seriously look at approaching individual targets to bring greatest impact. Professors, doctors, politicians, judges, leftists in general. Look up tactics used during Ukrainian civil war. During unrest, target both sides to increase tension. In other words, promote gun police to overreact, which should help to escalate violence. BLM protests or other leftist crap would be an ideal place to incite violence. Please send me your violence that I may unleash it into their hands. Guide my hate to make a lasting impression on the world. So be it. I don't know if there's any truly conspiracy of, and then they put in multiple parens, people, which is normally an indication for Jewish, out of presumably Jewish people out to destroy me and mine. But there is an attack nonetheless, which he spells in 3 separate words, incidentally. For that reason, I will strike. I can't just strike to wound. I must find a way to deliver the blow I cannot shake off. Many, many blows that will need to be turmoil. Yeah, so, he has some thoughts that he's written in a manifesto that he's written, and, he has some thoughts about some violence he might wish to ensue and chaos he wished to ensue and pitting people against people and, putting places and stuff and things and targeting people. He has some thoughts. These thoughts are not necessarily in any way healthy. I'm definitely not endorsing them. Pressing on. Hassan identified himself as himself, not me. This is him describing himself, not me. He described himself as a longtime white nationalist, having been a skinhead 30 plus years ago before my time in the military. Okay. Hassan's own writings were not only ones to raise flags. He compiled manifestos of mass murderers and terrorists. He sent himself a home workshop explosives handbook, the anarchist cookbook, and the terrorist handbook, which discussed methods of buying, preparing, and detonating various explosive substances. Yeah, he might be in some sense preparing for some things. It's not just the manifesto, of course. I mean, it's not illegal to possess any of these. Well, it might be illegal to possess some of them for all I know, but it's not illegal to possess many of these documents. But in context with the manifesto, it raises some concerns. Hassan also researched the movements and whereabouts of political figures. Joy, let's find more evidence that, he's actually serious about this. What additional evidence do we have that this is not just, friendly research or just merely talk? What evidence do we have to suggest he might have intent to follow through on these plans? Well, he searched for where do senators live, D.C.? Do senators have SS, referring to Secret Service protection? How often are senators in D.C.? How do senators and congressmen get around D.C.? That's a targeted searches there. Yeah. After viewing a headline in which Joe Scarborough, the television host and former U.S. congressman, called former Trump the worst ever, Hassan spent several minutes reviewing Scarborough's Wikipedia page before searching where is Morning Joe filmed. His searching led him to the address for Scarborough's home, which Hassan then viewed in Google Maps. This might be some actual preparation and planning. This might be a little bit more than, just merely some curiosity. This might be a little bit more in the sense of, planning, preparation, planning some, okay. In the government's telling, Hassan's inquiries about specified individuals drew inspiration from a different manifesto, Breivik Manifesto. On January 3rd, 2019, Hassan searched within that manifesto, which he saved on the Coast Guard's computer, for Category A. 2 weeks later, Hassan spent 3 hours compiling a list of prominent politicians, activists, political organizers, and media personalities. Again, this is, he's reading the other manifestos with, apparently to get inspiration from them and build his own plan in his old manifesto and searching for the places to see the DC Congress people and stuff. Yeah. And he stored the manifesto on a government computer, which was just particularly genius. Great way to go. Agents searching his home recovered over 30 bottles labeled as human growth hormone inside of a locked container, 5 vials of testosterone, and mestelone. In a 3-year period, Hassan spent roughly $12,000 on holsters, knives, ammunition magazines, ammunition, handguards, camping supplies, meals ready to eat, armor body plates, plate carriers, tactical vests and pouches, firearm repair kits, firearm components, and smoke grenades. Among those purchases were metal parts with pre-index holes ready to be drilled and assembled into unlawful silencers. In December of 2017, Hassan purchased scope for precision long-range shooting and bought a Bergara hunting and match rifle, outfitting it with one of the scopes and a bipod. The necessary instruments in hand, Hassan educated himself on precision long-range shooting. While at work, Hassan reviewed a document authored by a well-known expert on sniper training and operations. He then took his rifle to a gun range, test-fired it from various distances, and recorded his observations in a journal. The government forecasted an additional, more serious charge did not come to fruition. I don't know how, with all this evidence, I don't know how the additional charges didn't come to fruition, because it seems like a lot of evidence. But apparently the government's not interested in charging him with many, many things. So all we ultimately charged him with was unlawful possession of an unregistered firearm silencer, unlawful possession of firearm silencers unidentified by serial number, possession of a firearm by an unlawful user of an addict to controlled substances, and possession of controlled substances. So right away, I just like to say that this guy seems like the luckiest guy ever, because it seems like a lot of evidence that we could charge him with a lot of things potentially, but ultimately the government is only charging him with the unlawful possession of the silencers and the gun because he's a habitual user, and of course the controlled substances. So I think like already he's getting a pretty big break, but let's press on. The district court held a full-day sentencing hearing. Of note here, the court resolved the government's request to enhance Hassan's guideline range under the relevant law. So the government wants the sentencing enhancement for that. The district court applied the adjustment over Hassan's objection upon concluding his crimes were designed to promote a crime under the relevant law, which in relevant part criminalizes attempting to kill or kidnap any member of Congress, any Supreme Court justice, and certain executive officials. Applying the adjustment increased Hassan's offense level by 12 points and his criminal history category from 1 to 6. That's a pretty steep adjustment. The district court, however, decided to be merciful that day, and again, Hassan is like the luckiest guy ever for this. The district court, however, agreed with Hassan that the increase overstated his criminal history, and he departed back down to category 1, all the way from category 6. That's a lot of departure, man. I'm just saying, that's a lot of departure. But, you know, he applies the formula, the judge applies the formula for the various things and says, hey, this increases your offense level by 12 and also your criminal history score by 5. And that's a lot, because I think 6 might be the max on that chart, although I'm not 100% on that one. But it's high, right? And so the district court says, you know what, I'm going to give you a break. How about I take you all the way back from 6, all the way back down to 1? That's a lot of break. I'm just saying, man, this guy is like the luckiest guy ever. Still, in the end, it wasn't all great news for Hassan, because that changed the guideline range from 41 to 51 months to 151 to 188 months. Okay, having discussed a little bit about Hassan and his manifesto, some of the evidence against him, and the many, many breaks he got, like the government not charging him with more crimes, and also the judge just being unbelievably merciful that day, because although it suggested raising him to history 6, the trial judge said, how about for you, my friend, special price, category 1. That is a lot of break. And then basically sentenced him to the minimum within that new guidelines range. I mean, that's a lot. But of course, Hassan is not happy because he's being sentenced to a lot of time. So he'd like to appeal the terrorism enhancement. All right, so let's appeal the terrorism enhancement, see how that goes. Hassan mounts 2 challenges. First, he believes that the relevant regulation or law is ultra-virus to the extent it encompasses defendant not convicted of federal crimes of terrorism. Second, he contends the district court summarily disregarded his own expert's findings and opinion that Hassan did not present a risk of violence and so the adjustment should not apply to him. We disagree with both these contentions and therefore confirm the sentence. Yeah, I mean, there's plenty of evidence to go the other way, you know. The relevant crime applies that the offense is a felony that involved or was intended to promote a federal crime of terrorism. In a separate case, we subsequently agreed, holding the adjustment does not require the defendant be convicted of federal crime of terrorism, but instead applies whenever a defendant's offense or conviction or relevant conduct was intended to promote a federal crime of terrorism. On appeal, Hassan switches gears and argues that because the section applies to defendants who are not convicted of crimes of terrorism, it contravenes a 1996 congressional directive to the United States Sentencing Commission and is therefore invalid. I mean, nice tries and all, but this is not going to work. Grasping Hassan's argument requires understanding the history. Before 1995, the sentencing guidelines permitted terrorism upward departure where the defendant committed the offense in furtherances of terroristic action. In the Violent Crime and Control Enforcement Act of 1994, Congress directed the Sentencing Commission to amend its sentencing guidelines to provide an appropriate enhancement for any felony, whether committed within or outside the United States, that involves or is intended to promote international terrorism, unless such involvement is in and of itself an element of the crime. Less than 2 years later, in the Anti-Terrorism and Effective Death Penalty Act, Congress instructed the Sentencing Commission to amend the sentencing guidelines again, so the Chapter 3 adjustment relating to international terrorism only applies to federal crimes of terrorism as defined in Section 2332BG of Title 18 of the relevant code. In response, the Sentencing Commission changed the relevant crime to only apply to federal crimes of terrorism. Hassan contends the Sentencing Commission misread the 1996 directive. According to Hassan, Congress intended to restrict the section to cases where a defendant is convicted of an offense under the relevant law, which defines a federal crime of terrorism. Under Hassan's reading of the directive, the Commission should have made the adjustment to require the prior conviction. In his view, when Congress wrote the word only, they intended to narrow the adjustment in some way. But then in the same directive, Congress expanded the scope of the adjustment to include cases solely involving domestic terrorism. Hansen argues that limiting the adjustment's application to convictions for federal crimes of terrorism is the sole way to effectively narrow the quality of the word only, given the expansion that results from replacing international terrorism with federal crimes of terrorism. No, it's a little bit more narrow, because international crimes of terrorism doesn't necessarily mean a violation of U.S. law. So it is slightly more narrow to say federal crimes of terrorism, right? If you say international terrorism, that could presumably mean terrorism under presumably any country's law, or, you know, the respective country in which you're committing the terrorism, or respectively, right? So to say federal crime of terrorism is slightly more narrow than international terrorism, because it would only be terrorism as defined by U.S. law as opposed to some international law. So it's more narrow. Our review convinces us that the 1996 directive readily supports that Congress directed the Sentencing Commission to amend the relevant law, which then applied if the offense is a felony that involved or is intended to promote international terrorism, so that it only applies to federal crimes of terrorism, as defined in the particular law. That direction is reasonably read as instructing the Commission to edit the type of terrorism which the adjustment applies by replacing international terrorism with a federal crime of terrorism, which of course the government did. Attempting to overcome the Commission's reasonable interpretation, Hassan argues that legislative history supports his reading. He quotes the conference report, which states that this section of the bill will make the new provisions applicable only to those specifically listed in federal crimes of terrorism, upon conviction of those crimes, with necessary motivational element to be established at the sentencing phase of prosecution. But of course, as we all well know, legislative history is not law. Only the statute itself underwent congressionally required process of bicameralism and presentment. Therefore, these statements, even if they're by the author of the statutory text, or any other extrinsic material, are not material. This is completely correct, right? Especially to conservatives, right? We just look at the text, what Congress passed. The way to make a law is by two houses of Congress passing it. The committee report, while interesting, and the author's comments, while interesting, were not passed into law, so they're not law. They're just some guy's view, so they don't count, right? Moreover, even if we were to consider it, the conference report does not compel the meaning that Hassan attaches to it. Although one could read Hassan's selective quotations as requiring a conviction for federal crime terrorism, one could also read it as stating a sufficient but not necessary condition for applying the adjustment. Thus, that brings us to the end of the case of United States of America versus Christopher Hassan. In this case, we learned that a former lieutenant will be spending the next 13 years in prison because of he was a controlled substance user in possession of controlled substances and also had firearms, which is not permitted. Also, he had manufactured silencers. But this guy is like the luckiest guy ever because the government didn't charge him with a whole bunch of stuff, and then the sentencing judge, for reasons I don't understand, decided to downward depart his sentence. Of course, Mr. Hassan is not happy about the sentence, all things considered, and would like it reversed. But the Court of Appeals notes no, right? The sentencing guidelines are what they are, and they're completely consistent with what Congress wrote. So, instead of 4 years in prison, more like 14. But those are the breaks, maybe less with terrorism next time. And at least for the moment, that brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.